All right, welcome back to will construction and interpretation. The concepts of abatement and ademption are dealing with not people changes between the will execution and when the will becomes effective at the testator's death, but in fact, when property changes. The concept of ademption is when a specific bequest is no longer property of the estate. And the concept of abatement is when there is not sufficient property to fully fund the estate plan. All right. As part of a review, though, remember lapse and anti-lapse deals with a predeceasing beneficiary. You look to will for guidance, keeping in mind that the anti-lapse statute that applies in every jurisdiction requires it to be a default unless contrary intent is expressly indicated in the will. This anti-lapse statute is going to apply. So that's why you look to the will first. Then you determine if the anti-lapse statutes apply. They will always apply in Maryland because you're pushing it through the predeceasing beneficiary's estate. However, under the UPC, where you have a two-part test, it's possible that one of those two parts may not be applicable. For example, if you had a bequest to a friend, they would not satisfy the relationship test. So in that case, you default back to common law lapse. All right, so let's take a look at ademption and abatement. Ademption, again, deals with a specific bequest that was part of the will, like a house, and then when the will speaks, the house is not property of the estate. Perhaps the house was sold and the decedent was in a nursing home or renting an apartment at that time. The idea is that the specific bequest, there's no substitute, adeems. Too bad, so sad, specific legatee, you get nothing. The other concept is abatement, and there is a specific way in which the shortfall is distributed amongst the various classes of beneficiaries. First, you're going to use up all of the residual, then you're going to use up the general, then you're going to use up the specific. Okay? Let's talk about ademption first. Only applies to a specific bequest. So if you have a bequest of cash, you're not going to want to be talking about ademption. Most jurisdictions, including Maryland, apply what's called the identity approach. If the particular item is not property of the estate, the gift adeems. We don't care why it's not property of the estate. We inventory the estate as of date of death. It's gone. It's not there. And there is no replacement. Under the more modern approach, under the UPC, they may replace property if it's consistent with the testator's intent. So in a situation in which you might sell 123 Main Street and buy 456 Ocean Drive, same type of property, but the will specifically gave 123 Main Street to the beneficiary, there may be an argument that the property could be replaced. You would have to look to the facts because the intent test depends on the testator's intent. All right, ademption, it can either be because you lost it, it was destroyed, you gave it to the beneficiary, you gave it to a different beneficiary ahead of time, typically no replacement. Abatement, look how the property abates. If you look at the statute, Maryland statute is 9-103B1. There is a specific order in which property abates, and it goes from the residual to the specific. Remember, a demonstrative bequest will be reclassified as specific and general for purposes of applying the rules of abatement. All right. Abatement can also occur because of debts, liens, taxes, the elective share, things of that nature. We don't have a lot. When we drafted the estate plan, we had a very significant estate. Over the years, our estate has dwindled down, and we don't have enough to fully carry out all of the provisions of the will. It's not just a residual, but there may be no residual, but you also start eating into and are unable to fully fund the general and even sometimes the specific. The general class will abate completely before you look to the specifics. Potter, what is this? Is this in a situation of abatement or redemption? Take a look at the estate plan. Do you think it was the intent of the testator to prefer her daughter over her son? Probably not. What changes in the estate plan could have been made to treat the children equally? Is this abatement or ademption? McGee, same thing. Take a look at Grandma's estate plan. Do you think it accurately reflects what the testator would have wanted? Do grandparents typically favor friends over grandchildren? Probably not. Why does this outcome appear to be inconsistent with what the testator wanted, and how might you have changed that?